Refusing a breathalyzer, a chemical test, might feel like a smart move, but in California, it could actually make things worse. Technically, yes, you can say I'm refusing to take the chemical test, but this is not without serious consequences because California has what's called implied consent, which means that by driving on public roads in the state of California, you've already agreed to submit to chemical testing if you're lawfully arrested for a DUI. So what happens if you refuse? First off, your driver's license is immediately suspended for at least 1 year, even if you're not convicted of a DUI. And if the case goes to trial, the prosecution can use your refusal as evidence that you were likely intoxicated. Refusing a breathalyzer doesn't mean you won't be charged with a DUI. Police can still arrest you based on other evidence like field sobriety tests or their observations of your behavior that indicates intoxication. They can also get a warrant for a blood draw to test for your blood alcohol concentration or BAC. In fact, refusing the test can sometimes make your situation worse because it adds an additional penalty to your case. In one case, a client was pulled over for a DUI. He refused a chemical breath test. The officer asked him if he would agree to a blood test, and he refused that as well. The officers were forced to get a warrant for a blood draw. This added a refusal enhancement to his DUI charges. However, we were able to successfully negotiate a resolution that did not include this refusal enhancement. So if you're facing a DUI charge, it's critical to speak to a lawyer immediately who specializes in DUI defense. If you've refused a breathalyzer or are facing DUI charges, don't try to handle it alone. Call us today at 408-877-6177 and let's start building a defense that protects your license and your record.